This is Breakfast Central here on News Central. A year has passed since a devastating fire gutted the South Africa's National Assembly chamber, causing billions of rand in damage. Alleged arsonist Zandile Mafe is expected to appear in the Western Cape High Court today in connection with the fire. The 49-year-old made a brief appearance at the Cape Town High Court in November 2022.
His defense lawyer stated that they needed more time to go through documents provided by the state with their client. The arson accused has on more than one occasion refused to appear in court unless his demands were met, causing the state to question his mental state. Mafe is facing 4 charges, including terrorism and housebreaking. Joining us this morning to give more insight on this is human rights lawyer Barney Petiana. Good morning and thank you very much for joining us. Zandile Mafe has been awaiting trial for this case for almost a year. Give us context as to how it usually would happen in South Africa. Is that the case? Do accused persons usually have to wait for as long as 1 year before their matter has been attended to?
It is not unusual, but it's very rare. In fact, it should not happen. It is a violation of our constitution that the administration of justice system ought to function in such a manner that the accused in particular should not be prejudiced, at the very least, not be prejudiced by remaining in prison. Sometimes it does take long, but often the accused is out on bail. In this instance, the accused was arrested almost immediately after that fire. And of course, as you have stated, there have been issues as to whether he was of a sound mind to stand trial. He had to be sent to Falkenberg. He was also non-cooperative and he wouldn't come to appear in court in person. And even it got to the point where his attorney was really finding it very difficult to represent him and to take instructions as attorneys should do. So partly he is responsible for it, but I don't think it justifies constitutionally that the person should have been out for so long. For example, not enough reason, in my view, has been given for retaining him in custody for all this time. Because it appears that he has got family and relatives in Mafikeng, where apparently he comes from. He doesn't have an address, a reliable address in Cape Town because he was a homeless person. But his family have come up to say who he was, how they've been looking for him, and they live in Mafikeng. For that reason, it seems to me a violation of his rights that he should be kept in custody for this long.
All right, let's look at his mental state. Now, his mental state is something that has come up one too many times. The state believes he needs a mental evaluation. What would lead the courts to grant a request like that? Is this something done easily or does it take time as well?
Throughout, almost from the beginning, there were questions about his mental state. And of course, you must understand that the burning and arson in an institution like Parliament buildings that are really representative and reflective of the democracy of our country. So there were many people who were outraged that a person could have gone and managed to go in undetected. So the systems in the parliamentary building of security clearly must be coming under question. But the second thing is that having done so, and he burns the building and walks out of the building, and didn't appear to be compos mentis, as they say, after that. He then was sent to for observation, and his attorney at the time objected very vigorously, very strongly, that he should be sent to for a mental examination. Although later the attorney himself conceded that because he was not getting any cooperation from his client, he felt that there was something that needed to be examined about him. So yes, the truth is that if indeed there is sufficient evidence that his mental state is not such as to enable him to face trial, the court can actually determine. In fact, there's a famous case where a former apartheid Prime Minister Verwoerd.
Okay, you've just mentioned how his attorneys were strongly against him being taken for mental evaluation. Now, if you look at some of the reports, it would say that Zandile Mafe was very uncooperative. There were times when they would go into his cell and see him lying face flat on the floor. Times he would say he's not appearing in court unless he's given a television, a radio, and he's basically asked for things that seemed ridiculous. On the one hand, there have been conversations, some people wondering if he's an actor. In fact, some people have referred to him as an actor. Why would you say that, or why has his legal team all of a sudden, after initially saying they didn't believe he needs a mental evaluation, but now they've turned around to be warming up to the idea? And do you think that this could maybe count against him in the long run?
There are two phases to that. Thank you very much. That's a very good question. One phase is any attorney does want their client to appear before a judge and present his or her case. And that's the work of the attorney. At the same time, the attorney must act always in the best interests of the client. And thirdly, the attorney ultimately is an officer of the court. So an attorney as an officer of the court enables the court to come to the best position of justice in the circumstances. So in presenting the case of the accused, the attorney's job is to enable the court to come to an appropriate decision of the guilt or otherwise of the client.
All right, now let's look at this. This case initially seemed like it would be finalized very quickly, considering how quickly Mafe was arrested. But the NPA is going to need to prove their case beyond a shadow of a doubt. Now, what kind of evidence should we expect to see?
It may look like, for the time being, that the attorney may be advised, in the interests of the client, to pursue the case of whether the client, at the time, up to now, is in a state to be able to plead coherently to the case before them. That might mean that the client might actually not face trial in the normal sense, but might actually be committed to an institution. Whether that is in the best interest of the client or not, the attorney must determine. But the circumstances may well be such that, you see, there's no death penalty in South Africa, but it may well be the case that the attorney may be feeling that he would be serving his client best by making sure that he's committed to a mental institution. The second thing, however, the duty of the National Prosecution Authorities is to prove that this person did undertake this arson, is responsible for it, and secondly, that he did so with the intention of causing the damage that in fact was done. So it's at the level of proving mens rea or intention that the NPA has the most difficulty, I imagine. Because in the circumstances, to determine that this person had the appropriate intention in law is going to be very difficult, I think, for the NPA.
Right. On a final note, I'd like to ask something. So there have been conversations, and some people have expressed concerns as to the fact that the Phoenix Indians that killed black people, their faces were protected, and that on the first day of Bafile appearing in court, that his face was open and his face was exposed. You think that maybe they have a point of concern there, or is something to be looked at?
Yes, indeed, there is a fair point of concern, but we don't know what the circumstances were. It may have been the case that he refused to be protected or covered or whatever. And he was with his defense attorney. And by the way, interestingly, for somebody who is a homeless person, presumably doesn't have the means to afford legal representation in South Africa is very, very expensive. Although one can get legal aid if one cannot afford, but he had legal representation. He had an attorney. He had counsel almost from the beginning. So clearly somebody must have provided the resources to cover the costs of legal representation. So clearly in the presence, and it must have been with the agreement of his attorneys that his face was shown. And because the attorneys could have objected to that right from the beginning, and it would not have happened.
Right. So many angles to this conversation. Thank you very much for joining us to explore the conversation about Zandile Mafe. And we certainly will follow up with the case, and we look forward to having you join us again.
Thank you.